Good evening. It's June 20th, 2019, 7:15 p.m. We're in the Littleton Town offices. This is the Littleton Zoning Board of Appeals. We're at 37 Shattuck Street, room 103, Littleton, Mass. 7:15, we're going to start with new matters and the announcement of our new board members. So Mark Saucier, congratulations on moving on up. Welcome to the big table. Very, very happy to have you as a permanent member. And John Field, very happy to have you as our newest alternate.
Thank you.
And Rod and myself were reappointed, thankfully, so we're still here, and he's still stuck with us. This says reorganization of the board, but I think maybe we ought to agenda for next meeting to have elections, since we do have a new configuration on the board now, and we're going to be missing Alan Bell. Thank him very much for his many years of service and all of his contributions. He's decided not to serve again, and he was our clerk, so we will have to have elections for chairperson, vice chair, and clerk. We have minutes, but we have a very full agenda tonight, and I'm delinquent in reading the minutes, so I'm going to skip that for now and see if we get to it at the end. Accounts payable is sitting here, and I can do that at the end too and not hold up the crowd for that. We want to have a discussion. I would like to have a discussion about application fees, and I'd like to have you all thinking about that. We haven't raised application fees in a very long time, and postage is up, as well as the work requirements of getting the abutters out. We are beginning to see a lot more abutters than before, and the mail cost is up. And the work of the admin is up to make that many abutter notices. So we talked upstairs about application fees. We're going to do a comparison with some of the other towns and try to raise them a little bit so our budget can stay constant, as we've tried to do in the past. And I asked Mark Gallagher here tonight because there was some discussion during the week that there was some unfinished work at 15 Great Road. I'm advised that he met with the Highway Department and with Shelley earlier today, and with Roland, I think, with Shelley, and they have a meeting of the minds as to what's to happen. But since he was on his way home from dinner, and I thought we had a couple of minutes here, I thought I'd invite him so you could all take shots at him, and he could tell us what's going on and what we can expect with the project at 15 Great Road to be complete.
Good evening. My name is Mark Gallagher, and I'm from Seal Harbor. As you may know, we did the project as known as Wildflower Meadows, located at 15 Great Road, and we completed the project, well, almost 99.9% of the project, 18 months ago, roughly. There was 2 items that were left over. As you remember, it was a very large project. There was 56 single-family condos. There was an affordable component to it, and there was a lot of things that we had to bring together to finish it out. But as of to date, I think everything's housed and everything's going in the right direction. So the 2 items that we had left behind, which was more my fault than anybody else's, was we had to place, there was 2 items. We had to place bollards in front of 2 fire hydrants. Bollards are concrete lolly columns, and there was 1 hydrant that has to be picked up 12 inches. Those 2 items, for unforeseen reasons, I honestly, up until Shelley contacted me a couple months ago, I completely and utterly forgot, which was my fault totally, and I accept it. However, I have met with Deputy Chief Clancy from the fire department. He was very nice. He came out and met me today. We went over the things that what he would like to see, which was the bollard placement, roughly 36 inches off of the fire hydrants, placed at a 45-degree angle. So we have the exact locations of those. We actually have the bollards. We had brought them in 18 months ago, and I had put them away in storage. Once again, I forgot all about them. So we have those bollards. The fire hydrant itself, I have placed I placed the order yesterday for the 12-inch riser. I am bringing in a subcontractor to assist me in lifting the hydrant. I have to work with the water department. Obviously, they're off tomorrow, so I will contact them on Monday. We'll have to do a minor water shut-off, maybe for an hour or two, and we'll pop off the hydrant, put it on the riser, pop it back on, pressure test it, and make sure everything's going in the right direction. And I believe, at that point, I will be 100% done with the project.
So Shelley also mentioned tonight, as we were discussing your arrival, that there's one other hydrant that may not be your responsibility to raise, but you're going to have the equipment there. Is there some way we can get that done?
I am not bringing in any equipment.
You just said you've got a subcontractor doing it. Is there any way that subcontractor can get it done? What are we talking about cost, so the project is really complete?
Well, at this point, as you know, we finished paved. I do not own any machines that are less than an excavator that weighs less than 18,000 pounds that doesn't have tracks on it. You'd have to have a machine in the 6,000 to 8,000 pound range on rubber tracks, so you wouldn't damage any part of the road. That is, once again, I didn't go into depth with it with Deputy Chief Clancy. I don't know exactly if they wanted a 6-inch riser or a 12-inch riser, and I'm not sure. I would have to double check, but I'm not sure if it's the same hydrant that I installed. So there's different brands of hydrants. And once again, this was outside of our purview. That was more with the original developers who developed the main road.
Are you referring to the yellow one or the red one?
The yellow one. It's at the corner of Chamomile and Boxwood.
Why does that need to be raised up?
I'll look at it.
I don't even know if it does. Once again, I didn't get with Deputy Chief Clancy on that one.
Might be cheaper to bring the land down around it.
Yeah, because that one looks just
As a good neighbor and as someone who had a successful project here, is there any way you can help us out and see if there's a way that we can get that done in a fashion that the neighbors are happy and doesn't fall on the town to pay for?
As long as it can be done with a shovel work in and around there, if we could, maybe we can just decrease the overall grade by 4 to 5 inches. Conceivably, as long as it's just using a spaded shovel to remove that material, maybe down 4 inches. Sure, I can provide the labor to do that.
Could you report back to Shelley maybe what's involved? Maybe we can even get a couple of Eagle Scouts to work on it as a project or something and just get it done.
Sure.
Yeah, especially if it's just shovel work, so.
Once again, I'd have to confer with,
yeah.
It's really.
It doesn't fall in the Eagle Scout project venue, but also our fire chief is a very reasonable man. Just find out what he needs to make it safe and usable.
Yeah, I don't think that one is, there was one that was installed by our original subcontractor who did the road. Once again, it falls on me because I was a manager of him. He always promised to come back and to do it, to raise the hydrant up. Having never done it, but I'm told it's very easy to do once you dig it all around. It's conceivable that you could pop it on. I think the parts are probably in the $1,200, $1,500 range.
Maybe you could tell us who installed it, so.
Have you finished paying him?
The sub that installed it?
Which one?
The one that was supposed to do this?
Yes.
That's too bad.
Yes. Unfortunately.
The one that installed the yellow one is who I'm looking for.
The one was installed by the 15 Great Road LLC.
Yeah, but who was the contractor that installed it at the wrong height? I mean, maybe we can go directly.
Federino.
What?
Oh, I'm sorry, I'm using last names. I don't remember. I can't remember the company name.
Would you have a
It was
record of
Felix?
that, Shelley?
Excavation, there you go.
Thank you. Okay. Thank you. I didn't mean to put you on the spot, but
No worries.
I'd like to get the whole thing done and have the neighbors stop, complaining that things aren't done.
Yeah, I understand, so.
Thank you, and
very
thanks for
much.
stopping by.
Yeah, I miss being here, actually. It's been a while.
Every week, every month, just come on by.
We won't say we miss you.
Thank you, guys. I appreciate it.
I'm going to call the 7:15 PM public hearing, case number 923A, petitioner Susan Paul Souza, seeks a variance pursuant to section 173-10B2, non-conforming uses and structures for a proposed deck with a reduced setback at 93 Mattawanaki Trail. Good evening. You present. We will then have the board ask you questions. We will then ask abutters if they have any questions. Everyone will get a chance to be heard, but you present first and as informally as you'd like.
Okay. So I'm Susan Paul Souza. I reside at 93 Mattawanaki Trail in Littleton. And we're hoping to be able to expand. We have a back landing that's about 5 by 15 feet. And we'd like to be able to expand it to be 12 by 15 feet. What we have currently is do you have the pictures in front of you?
Yes.
You can see, okay.
I
So
just
we
turned
have-
around in your driveway.
Yeah.
That's the reason I was a few minutes late. Your
Oh, you did?
property is beautiful.
Oh, thank you. So there's a patio there, a stone patio there that abuts with this 5 by 15 foot landing. And what we were hoping to be able to do was to build the deck out so that it totally abuts with the patio. So that the deck itself would be, again, 12 by 15. The problem that we have currently with it seems like we have a lot of space there, is that there are 3 columns that come down about midpoint in that stone patio that support a porch that was put on. So we've lost about 8 feet.
This is on the back side?
Yeah.
Okay.
Yeah, so we've lost about 8 feet of width on that patio. And so we currently have about and the patio is a tapered patio. So it starts at about, I have my dimensions here.
Do you have any
About
kind
12 feet wide, and it tapers down to about 5 feet wide
Do you have any kind of drawings?
for the patio now.
Okay, so you want to put a deck.
Sure. Can you
a
present
plot
first and
plan
then
we
we'll,
have,
and then
yeah.
we'll.
And this,
That's not
it wasn't in what I printed out.
What?
This was not in our packet.
Can you pass it?
Cheryl, there is a,
Just so you could get a visual of.
Thank you. So you're talking about between here and here?
No, I'm talking about, can I approach you?
Can you,
here's,
yes.
Cheryl, here's this.
So I have a drawing here, and this is the house, and this is the patio, and this is the current deck right here, the small
Oh, I
one.
see.
And then this is the large deck, the deck that we'd like to be able to add on to. So it will totally abut with the patio.
Can you go around and show all board members?
Okay.
So
So coming off there. And the
So it's
package,
this here, so this is the current deck there, landing, and this is where the,
and your package says you've satisfied the Conservation Commission?
we satisfied the conservation. We actually started out with a larger patio, a larger deck, and they asked us to bring it back down. And so we brought it down. We wanted to have it to be about 15 feet wide, and we brought it down to 12 feet wide. So this is the current deck. This is what-
I printed out the whole package.
It's also.
So your picture says 11 feet, the new deck will be 11 feet from the rear lot line?
Correct. yeah.
And the zoning officer says approximately 10 feet, is that, Shelley, is that
It's the lake, so it's.
hard to tell because of the watermarks? Okay.
Yeah, off of the plan.
I think I understand.
Board members, any questions?
Setback, is that 7 feet? Is that 7 on the drawing?
How
sorry.
close will you get to the front? Yeah, you will still have a setback from the front from the lake. Your property line goes to the lake. How far is the setback?
10 feet.
Okay.
Okay.
And-
11 feet,
and-
actually.
And
It's
on
11
the,
feet.
and on the side, how far are the setbacks from your new deck?
On the left and the right side?
Looks like it's gonna be 7 feet?
8 feet is what the building inspector letter says.
Well, there's
Okay.
plenty on that side, and this side they're not adding to it, the patio's already.
Right.
Okay, so it goes down to 8 feet.
Right.
The writing on the top
But
is
that deck is already there.
Right.
She's
That's
adding
the
more to it,
patio
though.
that's currently
Right.
there.
But the
Yeah.
actual ad wouldn't be in the setback.
Just the rear setback.
It would just be the rear
Just the rear
setback.
setback,
It's
right.
only the rear setback that's affected by this.
Which is the lakefront.
Correct. Yeah.
Where's this 7 foot? See that 7 foot plus or minus? What is that
This
depicting?
is, I think, depicting the width
Okay, of the new
of the new deck.
addition.
Yeah.
And what have we got for a side setback? 14 to here? And how much to the patio?
Well, this patio exists.
Okay. Okay. All right, board members, any other questions?
I think this one, there are orders of condition that have been issued by the Conservation Commission and been filed, so that we have to,
So, what do they want you to do in general?
well,
There's
I mean, I
a-
know there's all kinds of things, but
Right.
basically,
There's a lot of grading that they want us to do, yeah, so that.
silt fencing and,
Hay bales and,
Yeah, initially,
Yeah.
all of that silt fencing and, all
we
of
have to have
that.
a trench, 2-foot trench that we then
Right.
backfill with compost, and then there's edging on it, and there's required plantings, pollinators that have been put in, so we have a planting drawing, like a
Which I have.
siltation drawing, we have the architectural drawing that was all submitted and accepted.
How high off the ground is that gonna be?
About, not quite 2 feet, about 21 inches.
And it's gonna be on sonotubes?
Yes.
Yeah, okay. Anybody, any abutters to this application?
I have-
93 Mattawamkeag?
2 letters from our abutters.
I'd like to have them read into the record, please.
you want me to read?
Please.
Dear ZBA, we have been made aware and shown the plans of the proposed deck expansion at 93 Mattawamkeag Trail as submitted by the ZBA by Philip C. Souza and Susan Paul Souza. As direct abutters to the property, we have no objections to the proposed deck expansion. This is Michael and Janet Fields at 95 Mattawamkeag. And then we have Kevin Eastman and Ann Donald at 91 Mattawamkeag. Dear ZBA, we have been, it says exactly the same thing, made aware of and shown the plans of the proposed deck expansion at 93 Mattawamkeag Trail as submitted to the ZBA by Philip C. Souza and Susan Paul Souza. As direct butters to the property, we have no objections to the proposed deck expansion, and both of them are nicely signed.
Thank you. I'll put those in the file and ask someone to read comments from the zoning enforcement officer. Wanna do that?
Without stuttering?
The applicant seeks a variance from section 173-10B2, non-conforming uses and structures for a proposed deck. The current non-conformities are lot size, 14,014 square feet, frontage 75 feet, side setback 8 feet, granted in 2004, case number 659A. Front setback, accessory building 15 feet, granted in 2001, 594-8, so this property's been before us quite a bit. The applicant wishes to extend a 5x15 deck to be 12x15. Note that the building department has no record of the 5x15 deck being permitted. The Souzas are new owners and have been advised of this. The deck does not meet the required 15 feet rear setback and requires a variance due to creating a new nonconformity. In 2004, a special permit was granted to allow construction of a roof extending from the front along the side of the house for a reduced 8-foot side setback. The building permit for this project also included a second-level balcony to be approximately 22 feet from the rear setback. The decks were not included in that proposal. The deck as proposed will be approximately 10 feet from the rear setback, which is Lake Mattawamkeag. The Souzas have received an order of conditions from the Conservation Commission. So that sums it up.
Okay. Anybody want to close the hearing?
I make a motion to close the hearing.
All those in favor? You want to deliberate, or do you want to make a motion?
I make a motion to grant the, wait a minute, let me see if I can do this right. Is it a variance or a,
It's a variance. Go right back to the,
yeah. I make a motion to grant the variance from sections 173-10B2 for conforming uses and non-structures as requested, for allow a setback of rear setback or side setback,
Rear
Number
setback.
setback.
a rear setback of 10 feet for an extended deck as shown in the application of case number 926A for 993 Manawanaki Trail. Does that do it? Thank you. It gets confusing.
I'll put the deck size on that motion, approximately 12 by 15,
Approximately 12 by 15.
and no closer to the rear setback than 10 feet. No.
Yeah, that's,
Do we need to address the 8-foot? No, we don't need to.
No, that's all passed.
Can I
Okay.
have a second to that motion?
Second.
All those in favor?
Aye.
Variance is granted.
Thank you very much.
You're welcome. Thank you very
We have a
much.
very pretty
See
property.
you tomorrow.
Thank you.
Yes, I found it.
Can we all come and sit, can we all come and sit on the
Can we
deck when
sit
you're
on your
done?
deck when it's done?
Have fun
Selectmen
tonight.
had a designated.
Why don't you guys
One guy
come?
made all the motions.
Oh, that's
We
fine.
sent you an invitation. I did send you an
Oh, it's
invitation,
also-
didn't I?
Saturday?
Saturday?
No, last time.
Oh, the bed building. Thank you for going. I'll send you a note.
Okay, getting right along, we got a crowded night here in a crowded room. 7:25 PM, calling the public hearing, case number 925A. Petitioner Charles Bell seeks an appeal of the decision of the zoning enforcement officer dated April 2, 2019 regarding use of the property at 474 Great Road. Once again, petitioners present. We do have the the zoning enforcement officer here to defend, and we'll hear you out.
Thank you. Good evening, Madam Chairman, members of the board, new members of the board. My name is David Rosen. I am an attorney from Waltham, Massachusetts, and I have the privilege of representing Mr. Chuck Bell and his business, Neshoba Security, which is located at 474 Great Road and has been located there and operating there for more than 20 years. As an administrative matter, I was asked to bring a check for the publication costs, and I have a check for the town. Thank you. We're here to ask the board to rescind the notice of violations as set forth in the letter from the Assistant Zoning Officer dated April 2nd, 2019, for both legal and equitable reasons. We take the position and we challenge the zoning officer's finding that this property is zoned residential and retail sales service is not a permitted use in this district. Since 2011, Mr. Bell has been taxed commercial rates for his property at this location because it's been zoned both commercial and residential. The nature of his business hasn't changed in over 20 years, but for the past 8 or 9 years, he has been paying commercial tax rates for the property. So we take the position that the notice is erroneous on its face for that purpose. In addition, the property is currently in the new overlay commercial district approved by the town, which permits commercial use at that particular location. So again, we challenge the officer's findings that this property is zoned residential, it's now in the commercial overlay district, and his business should be permitted to operate as it has been for over 20 years. On a more equitable basis, Mr. Bell tried to relocate his business. He bought the property, the post office building, several years ago and wanted to move his business to that location, but he was asked by the town and also by federal employees, including the Postmaster General, to allow the post office to continue to operate at that particular site, and he acceded to that request and did not move his business to this location to allow the post office to continue to operate and to keep his business where it was located. So it sort of strikes me as you know, wholly unfair to try to now assert and allege that his business is violating a residential zoning law when he tried to move it to another location and was asked not to do that, and he acceded to that request. So for these reasons, both legal and equitable, we're asking that that this board rescind the determination that his property is in a residential location. That's just not an accurate assessment of his property. the statement that this use is considered compatible with the residential character of the area and is considered prima facie evidence that business activity is not incidental to the residential use. He's been operating his business there for 20 years. That's just not an appropriate statement. Our position is further set forth in my letter to the board dated May 1st, 2019. We stand behind that letter, and we ask the board to take appropriate action based on this submission. If you have any questions, I'd be happy to answer them.
So before proceeding further, I just want to announce to the board and to the, for the record, I had some involvement with Mr. Bell back in 2012 under the conflict of interest laws. I have had nothing within the last year, and I have no financial interest in the outcome of this matter. But I wanted to make that very clear because I think my name is on some of the
Does it matter if
papers.
we've hired Mr. Bell?
Pardon me?
Does it matter if we've hired Mr. Bell to do work?
If your office has hired Mr. Bell to do work?
No, does it matter if one of us is hired?
No,
Mr. Bell to
because,
do
no,
work?
because that's not a conflict in this matter, and that's not a financial interest in the outcome of this matter, and we have that happen in this town all the time. So if anyone has any objections, speak out, but I don't think I have any conflict. Proceeding further, does the building inspector want to respond?
I'm gonna
Zoning
respond. It was
enforcement
my
officer.
letter.
Yep.
Okay, so, first off, his Attorney Rosen's statement that the property is zoned residential is both factually and legally incorrect. It's not a correct statement. The zoning map,
No, you mean zone commercial.
You meant
no, the property is zoned residential.
Right.
And his statement in here says the town's notification that the property is zoned residential is therefore both factually and legally incorrect. That's an incorrect statement. The zoning map's up here on the screen. It is zoned residential. I have the property card that shows that the zoning is residential. And the statement that he does pay commercial taxes, the assessors do tax a portion of his property at commercial, but that has nothing to do with the zoning district, and that's very common. I have 4 other similar properties whose property assessments show different zoning, residential zoning, yet different tax rates for the uses of the property. So I can pass those around if you want.
Since when did our assessors board get to do that?
That's just the way they base their assessments. That has nothing to do with what the zoning is. The zoning is residential on the zoning map. The property was added to the overlay district in 2011, but that doesn't offer him the protection of making it commercial use. And if you look at the planning board minutes from that public hearing that I've included in the notes, it talks about that the property is zoned residential. It could remain a residence. This is the first time residential property will be included in the overlay district. There's no talk of rezoning the property to be commercial. It just expands the village overlay district to include this parcel. The problem with that is that in order for him to have the benefit of that overlay district, he has to have between 3 and 25 acres, which he doesn't have. So he would not be able to obtain a special permit through the planning board under that overlay district. So I'm not really sure why they put him in that district, because it offers him no protection. When Mr. Bell came in, he said he had had some special agreement with the town, but didn't provide any information.
I did.
So-
When did I say that?
One second,
When you
Ms.
came into
Bell,
the office?
let her
I
finish
did.
her side, and then you
So-
you
When did I
can
come into
rebut.
the office?
Counsel, would you please ask your client to wait his turn?
So I spoke with the planning board, who basically reiterated the same things that I've just said, that it is zoned residential, that it is in the overlay district, but he has never obtained a special permit through the planning board, nor would he be able to because of the size. I further sent it to town council for an opinion, and he sent me back this letter June 17th, which I included in your packets, which basically agrees with my findings. specifically saying, if you go to page 2, that he concludes that my April 2nd order, letter, the order violates section 17354, which is the home occupation law, which is what we have on record for him for use of the property as a home occupation. The reason the letter was sent is because he has anywhere from 4 to 10 vehicles on the site every day. Town council further states that although the property is in the overlay district and the petitioner feels they are protected by the business use, it does not. 173 allows for certain commercial uses in the overlay, but it must be established by a special permit from the planning board. I understand the owner does not possess such permit, and additionally, the property is below the minimum size necessary to be eligible for a special permit. Accordingly, the presence of the property within the overlay offers no protection for commercial use.
Mr. Bell, you want to rebut or counsel?
Yeah, I submit that it's disingenuous for the zone, for the officer to suggest that Mr. Bell's business, which has been operating at this site for over 20 years, now suddenly violates the zoning of the town. The Town of Littleton assessment card, which is in the package that we submitted to the board, states right on it, this parcel contains 0.4 acres of land mainly classified as res/com, with a colonial building built around 1900, having primarily vinyl exterior and asphalt roof cover with 1 unit, 2 baths, hay bales. The town's own records identify the property as residential, commercial. They've been paying taxes for the past 8 years for a commercial property. We again submit, it's disingenuous now to suggest that his property is not properly zoned for the business that he's been operating there for 20 years. And I would ask the board not to further that finding, that conclusion, and to rescind it.
On file with the building department, when a person wants to do a home occupation, which is allowed in the town, we have a letter from November 7th, 2008. Dear Roland, I'm requesting a business certificate to continue operation at 474 Great Road under the name Charles Bell, DBA Nasoba Securities. There will be 1 additional employee full-time other than myself at this location. A home occupation letter was issued on November 8th. Another point being, back in 2006, the building commissioner had sent a similar violation letter because he was exceeding the home occupation bylaw, and that case was resolved in April of 2007 with a note saying the business was relocated to a different address. Then, again in 2008, he applied for another home occupation. So he's been under the home occupation
Both
bylaw.
of those predate.
That wasn't a
both-
home occupation.
Excuse me, both of those predate the overlay district enactment, correct?
The overlay district doesn't
Doesn't matter, I'm
protect
asking
him.
the question. Both of
Yes.
those predate the overlay district. I also wanted to ask you, you said you spoke to planning board and got their interpretation. Who on the planning board did you speak to? The
I spoke with
administrator?
the town planner, Maren Toohill.
To whom? Board members' questions, Cheryl.
I'd like to discuss, but I'd like to do it without closing the hearing so that we can ask them questions.
Of course, we don't want to close
I
this
would like,
hearing.
I've got some very conflicting opinions and thoughts going in my head that I need to resolve. But are there any butters I'd like to hear?
I want to hear from board members first, please. Any board members?
I don't have
I
questions.
have a question of, the attorney. Is it factually incorrect that it's in a residential zone?
Yes, I believe it is factually incorrect.
It is not factually incorrect that it's a residential zone. It is in a residential zone. It's on our maps, it's on our, now, this doesn't mean that I'm not sympathetic.
My address is Great Road, it's not Russell Street.
It doesn't matter.
It does
There's a
matter.
map
You
right
built
there.
a police station
Number
right
four-
beside me.
number four.
Okay,
Number
tamp
four.
it down. We have a lot of things to
I
talk
guess I
about.
just want to be clear that this is a stinky situation.
No question.
But it is in a residential zone. I have no idea, you may have a perspective on why it was included in the overlay district.
I would like to address that. Do I have abutters in the room on this matter? Okay. I would like to address that. With the package, provided with the package, were some minutes of the planning board decision to include this property in the overlay district, and I was very heavily involved at the time. As many of you may or may not know, I owned the property across the street, which was the now Town Fair Tire Building, and at the time, Sam Park was developing the big mall up there. There was a lot of conversation in this community about bringing the overlay district all the way down Great Road, past my two buildings and Sam Park's building, for the very reason that all of us were coming together to make Sam Park's vision for that street a reality. That involved highway widening, several sets of lights, several cooperation efforts with MassDOT, and we were all asked by this town, by the planning board, and by Sam Park and the developers for that project, if we would all join together in cooperation. At the time, Mr. Bell was asked to include his property in consideration for the overlay district because they were going to put a street light there, right there, almost in his front lawn. In fact, if I'm not mistaken, they had to take an easement or make a land swap with him or something to get that street light on his front lawn. At the time, Mr. Bell was not generally in favor of switching to commercial, but we all worked very hard to talk about what might be in the best interest of the town, including the planning board. And the minutes reflect that let me just get here. There was a $1.8 million, $1.8 million grant for improvements on Route 119, and it was time sensitive. The town requested a permanent easement from Mr. Bell for a traffic light mast and a temporary construction easement for roadway improvements. Ms. Gould indicated that Mr. Bell is concerned with runoff from the roadway onto his lawn, and he cited drainage problems along Russell Street. She stated that Mr. Bell wants to cooperate, but his property is zoned residential, and with losing all his frontage when he's ready to resell, that would be a concern. She stated the question was if the board would support pulling his corner lot into the Area B overlay district. She stated that now it could remain a residence because it's still in the residence zone, and when he's ready to resell, it could be sold, parenthetically, as either a residence or commercial. She stated that the site plan review process could oversee what goes there in the future, and this should leave the owner with some options.
Did you represent Mr. Bell?
The planning board, at that time, I represented Mr. Bell in cooperation with all of us trying to rezone for many purposes. At the time, the planning board said they couldn't do Mr. Bell only because that would be spot zoning, and so they had a second hearing where they asked the next owner, Anrit Shadhuri, and he stated, it said, the hearing was open with the reading of the hearing notice. Mr. Montanari provided an overview of the proposal, stating that the two parcels at 474 and 478, 478 being Mr. Shadhuri, were being looked at to include in the Area B or Beaver Brook Overlay Zoning District. He stated that with the reconfiguration for Route 119, this is Mr. Montanari, it makes more sense for them to be commercial rather than residential, and he suggested adding the 474 Great Road parcel, since that was the only parcel between the Bell property and the Littleton Police Station, so it would give both our owners opportunity to change their use to commercial use if needed, and it gives the landowners some more options. Shadhuri stated that they had several questions. He stated their property value drops every year due to their location on the highway, and with 2 lanes in each direction, it will become less valuable. He asked if the property would be taxed as commercial, which is a higher rate than residential, and I stated at the time that if your property is lived in as residential with no change in use, even if you're in the overlay district, the tax rate would remain residential. She stated if the use is changed to commercial, then it's taxed at the commercial rate. Mr. Chiduri asked about details of the proposed roadway improvements and the impacts to his property. Mr. Montanari stated that the work on the roadway was all within the state right-of-way. Mrs. Toohill noted that the work would extend the pavement towards their property line and provided a portion of the plan showing the improvements. Chidori talked about the property lines. Mr. Clyde noted that he wanted to meet with both owners on site because Mr. Clyde wanted to support the extension into the right-of-way. And Mr. Montanari asked Mr. Chidori if he wanted to include his property in the overlay expansion, and asked Mr. Bell if he had any concerns or input, and Mr. Scott stated that if it were him, he would jump right on it. This gives you another option for selling the property in the future for commercial use. Mr. Bell stated he had asked for his property to be included in the overlay district. With that in hand, I also spoke to Planning Board Chair Mr. Montanari tonight to ask him what his memory was of this.
Can I ask you a question
Yes.
first? What you just read were actual minutes.
These are actual minutes of the Planning Board.
I'm a little troubled by them.
Why? They're minutes.
You just read that you represented this gentleman.
I made that announcement. That's 5 years ago.
Okay.
So the point being that, this is the point I need to make. What I think happened was that everyone intended for this property to be included in the overlay district, to have the option of being used as a commercial use, but they didn't change the overlay district to change that 3 to 25 acre requirement. So I think the building inspector's conclusion is not wrong, except that I think it was always intended that this property not sit on a 2-lane wide, you're disagreeing with me.
Very much. The zoning change has to occur at town meeting vote, not through this overlay, because they do not enjoy a 3-acre minimum standard. This is a town meeting vote. This is not, shouldn't be a variance process, and it shouldn't be an overlay
That's what I'm getting to. That's what I'm getting to.
Thank you. I'm sorry.
And I think, and I'm sorry, I didn't mean to cut you off. That's what I'm getting to. The overlay district was a 3 to 25 acre minimum. That was a town meeting vote to pull these two properties into the overlay district. What wasn't done in that vote was to change that 3 acre minimum.
Agreed.
But when I spoke tonight with Mr. Montanari, who chaired the planning, I don't know if he chaired it, he was certainly vocal at this planning board meeting. His memory also was that they intended for these properties, his and Mr. Chidori's, to have commercial treatment and neglected to do the next step, which was to bring them into the vote. Otherwise, it would have been silly, because why would you bring them into the overlay district at less than 3 acres and expect them to enjoy the commercial?
I agree.
So I agree with you. Now, what I don't know is whether, and forgive me, anybody can say something different. What I don't know is whether the zoning change for the commercial has to go back to town meeting, or whether planning board has the ability to waive the 3 acre for a parcel, but it's not us. I think it's not us.
I do think it would have to go back to town meeting to make that kind of zoning change. All zoning changes like that are required to be at town meeting. All that, please be quiet for a minute. All that being said, my sympathy is with you, so you let me get through my spitting out, okay? Because I have sympathy for you, I understand. I've never hired you, I was questioning other people, but I have sympathy for you because of your location and what's happened. But I don't think we can say he is commercial. And I certainly don't understand why the assessor's office thinks that they can bill people as commercial that are residential. That is ridiculous.
We're
and
not,
should be,
we're not
and
here
should be
to
addressed
pass
by
on the
you.
assessor's
But
practices.
on the other hand, your property is ridiculous to be residential. It is on the corner. It is your business has grown dramatically. The advantage of being in town here a long time, more than 50 years, is that I've seen your business grow over the years. It surely probably was an in-home occupation at the time you started it. You do have, the way that business and that land has grown up, it is ridiculous not to be commercially zoned, but you aren't. So we have to find a way out of this. There's no abutters complaining in here.
According with the intent that everything happened, this is my 3rd time up here. I keep paying lawyers, and the town keeps saying, okay, continue doing your business. Nothing ever gets rectified, nothing gets changes.
So let me try to get you on the right track. So let me
agree.
try to get
Thank
you on the right track. First of all, I don't see how we can overrule the building inspector's determination, which I believe is factually correct and which I believe is supported by the evidence the way it sits and town council's opinion. However, I think we have the power to extend the time period for enforcement of the building inspector's determination while this gets worked out. And when I spoke to the planning board members tonight, no conclusion was reached. It needs to be properly agended before them. But one possibility is that you go before them with a request to be legitimated and ask them if they can waive the 3 acres. They may say that you have to come back to this board to get a variance from the 3 acres. I'm not sure, I read it fast tonight. I'm not sure if our board has the power to waive or give you a variance from that 3 acre minimum, the way that bylaw is worded. And I think Mr. Bernier can help with that.
I'm as confused as you are.
I'm very confused by it, and nobody wants to shut you down and put you out of business. What we want to do...
Doesn't feel that way.
What we want to do is find a way to get you there lawfully and legitimately. You definitely are
How
on...
many times do I have to come up here and do this?
It's got to be done the right way.
I'm a small business. I can't afford to be paying lawyer fees every 4, 5, 6 years and come here before the town and try to represent myself with all the intent of that side of the town saying, you're okay. I remember back when I intended, and everybody in town knew I intended to go over to the depot where I bought the post office.
Well, not everybody in
First
town knew
phone
that.
call I got was from Roland. Roland, Chuck, can you come into my office? I have a problem. Did I come right in?
Sure.
Was there a problem? No.
What I'd like to do, Counselor...
I know you don't. I'm trying to present my case that I'm very passionate what I do, and I'm very good, and I take care of almost all of this town.
What I'd like to do, Counselor, is ask your cooperation in allowing us to continue this. For all of us to inquire whether the planning board can do this with a waiver from the 3 acres, or whether this has to go back before town meeting for a town meeting vote. But I would recommend to this board that whether they make a decision tonight on the building inspector's, your request for an appeal of the building inspector, enforcement officer's opinion, I would ask this board to give a good, healthy period of time for enforcement so that it enables your client to go back and get the proper approvals. I don't think anyone in this room disagrees that you are in a location that should be commercial. You don't have a single residential abutter. You're on a 2-lane highway at a major intersection right now. You should remain commercial at that location. I do think there's been some talk in the past about some trucks blocking the view to the left when they stop on Russell Street, but I think you took care of all that. I don't think this is a problem property. I think it's unfortunate you're sitting here, and I think it's unfortunate that we can't get you here tonight, but I don't see that this board has the power to overrule the building inspector. What we do have is a lot of vocal members who can support your position loudly in front of the planning board.
Thank you for it,
So
but at some point, it's got to get settled.
So there are no butters in this room that are unhappy. So if we give them a year,
I don't care if we give them a year, but
Can we indefinitely continue it while we work with the planning, while we...
We can't indefinitely continue it. Pardon me?
Yeah, they have a date, you can't just go.
just give them a year, that gets time to get to
But
town
we
meeting.
can't continue for a year. We have to give a decision on his appeal. And I really don't mind denying your appeal and asking you to bring it back as a variance if that's the right route, or bring it to planning board with a waiver request. And I think you can get there informally at their next meeting and have this out and decide with planning board the best route. If planning board thinks, all of us think together that this board has the power to give you a variance from that 3 acre minimum, which
I don't
is
think we
the
do.
only problem.
We don't have the power.
You don't know that without looking at the, I've been looking at it. It might very well be that we do. But planning board thinks we might.
Well, you kind of stole my thunder because it was clear with the planning board what their intent was. So my feeling would be to have them go to the planning board, see if they can get the special permit and see where it goes, but give some kind of an extension to cover at least the special town meeting so that, they don't start getting fined.
Can we
We
extend?
gotta go to fall town meeting
Yeah,
because he
November
won't
would
get
be
on
the
a
first
special.
one. So can we extend
good
for
fall
6
term,
months?
And I think planning board would bring that before the town meeting without you engaging council. I think once they hear that this happened, very clear to me when I spoke up, offline to Mark before coming here, it was very clear to me that he's only one person. It's got to be a full board consensus, but very clear to me that they never would have put you in the overlay as a property under 3 acres if they intended for this result. I think that's really clear.
Madam Chairman, I could be wrong, 'cause I'm not as familiar with the town, obviously, as you are, and members of the board are, but I don't recall seeing anything in the vote that came out of town meeting that had a 3-acre minimum requirement for commercial property.
The problem is, he got
vote-
into the mixed-use overlay, and the Littleton Village Overlay District, West Beaverbrook area says that you can have a variety of balance of commercial uses and retail uses, and Jeff, you pointed out to me, however, you have to have,
The public notice made no mention
No,
of
it
the
says-
3-acre requirement?
No,
The
it's,
vote made
it's
no
just
under,
mention-
puts
it's
you
under
in
the
the
it's
overlay.
under the site plan, the planning board site plan review, under this overlay district.
master
They
plan
can, they
developments.
can
yeah.
review, you can propose anything, according to their, the very broad categories, as long as you have a 3 to 25 acre parcel. So this is just as a loophole that applies to you and your neighbor's property, maybe only.
Only.
And it's simply a loophole, and unfortunately, that's what our board has to deal with all the time, where these broad things don't all get together. But the planning board should rectify it. They, and of course, it's a different board now, but I think that your property is so clearly,
It's 173, 169.
I mean, we're all familiar with it
Counselor.
because we wait at the lights constantly,
I can't
so-
imagine that town meeting wouldn't approve it immediately. I just can't imagine. I go to all the town meetings, I can't imagine that it wouldn't be approved right away. It's just that the building inspector is correct, and they are doing their jobs, and that is the way, what they've done and what they've researched is correct. You've fallen into Jeff called it a loophole, I would call it a crack. You've fallen into a bad crack.
I understand that. I get it. That's bureaucracy. Why wasn't this rectified back when I started paying commercial taxes?
I don't-
Am I entitled to get my commercial tax back from this point?
I would certainly ask for it if I
I'm
were
telling you that you're not, and that's because the taxing authorities have a right, and I've gone through some tax abatements, so I know this, they have a right to tax for the use you're doing. Your commercial use there, they have a right to tax you commercial rates. That's an unfortunate
they?
byproduct of all this, yes.
I didn't even know that.
I've got
And
a
if
whole
you're-
pile of them that are
And if
similar.
you're in a
Whole
commercial
pile of
zone
them.
and you're residential, they have a right to tax you residential rates, so it works both ways. But I'm telling you that I think that you've started a ball rolling of a lot of conversations
Tax my
among
entire
boards.
property is
I'm
commercial.
telling you that I think planning board, I think, Roland's even shaking his head, I think he doesn't disagree with me, that we're stuck with a zoning bylaw that we have to deal with legitimately. It says that use variances cannot be permitted by the zoning board of appeals under the Littleton Village overlay. It doesn't say other variances, like from that 3 acres.
Well, my intention is to call town council and just ask them.
Yeah, let's see if we can give you a use variance here, we'll notify you, Dave, to just go ahead and apply for a use variance. I'm sorry, no, can't give use variance, a 3-acre variance to that one section. And if we can't, maybe we can ask town council if planning board can do it, because we want to give you relief, and we're going to try to do that,
What
and we'll
other
try to do that
properties fall
together.
into this
So-
overlay? Can I ask something? What other residential properties fall into this overlay project?
Just
Just the
those
two.
Yeah, just those two, and they got sucked in because and I said it, in the minutes, I said it's time sensitive. Sam Park was beating on us to get the approval so he could open his doors,
Sorry,
if you all
interrupted.
recall. And we had to get the highway department in, and we had to get the lights installed.
Yeah, the only comment I'd like to make is, even if it was allowed commercial, it's a pretty small lot. Are there, and perhaps Roland could answer that, are there zoning requirements for businesses to number of parking spots, things like that?
Whoa,
I mean,
whoa, whoa. Now we're
let me
opening another
finish,
can of
please, you're not
worms.
helping your case.
Well, that
I
would
get
be
interrupted.
Oh, you took 15
Let-
feet
no,
of my
let me
property and
finish.
3 or 4
Let him
parking
finish,
spots.
let him finish.
I'm trying to make sure that let's say you do get zoned commercial, which would be good, and you can do business, but your business is obviously growing, which is to your credit. are we gonna run into the problem in 2 years where, yeah, it's a commercial zone place, he's running a business, but gee, there's not enough, there, it does no longer comply
The way
with the
the
number of
overlay
parking spots,
district, the
things
way
like
the
that.
overlay district works is that these properties would be subject to site plan review by the planning board. At this point, they can't do a site plan review because he's under 3 acres. But if this is waived or there's a variance, then he could, and you would have to deal with that. You would have to deal with a site plan review by the planning board, like any other business.
My
So,
basic comment would
one-
be that you might want to do a pro forma site review and make sure that even if you do get commercial designation, that, yeah, you can still operate the size of your business there. I'm
What I'd like to
just
see.
presenting that to prevent running into
Yes.
another bureaucratic issue.
Can you vary the home
I know,
occupancy
there is.
Yeah.
I get it.
limits?
No.
I don't think we can, John, and that's a really good question. I don't think we can, nor do I think we want to. That is one issue that comes up almost too frequently for us to establish
That would be
precedent
a
in that
horrible
regard.
road to go down.
Yeah, yeah. That's not a bad thought in terms of this particular property, but I'm
of people in town.
I'm afraid
Oh,
to
my
go
God.
that route. We
We-
have
we-
that
we-
happen
we-
way
we-
too often here.
we-
Well,
we
one of the
beyond-
things we're gonna try to do is establish maybe a contractor's yard definition, so that we stop having to deal with this with, well, people like yourself. I mean, you're probably don't have 1 million employees on site. What you have is a lot of trucks that have to be dispatched. And I
We've
think that
been
happens
parking them up
frequently.
there behind the post
Yeah.
office. I cleared out a spot.
Yeah,
You know, I'm trying to accommodate, I've always tried to accommodate the town. And
Yeah.
the town always kicks me in the ass.
Okay, so question, as an approach, can we stay the building inspector's decision for 6 months, continue the hearing to our December meeting?
we can stay enforcement action for up to a year. That won't bother you, right?
No, it's been policy in my office, as long as the applicant, and as long as the board is comfortable with what's taking place and it's actively being pursued, we don't pursue this until such time there's a definite conclusion and
So, Counselor, if we deny your appeal, which I
But
think we
stay
have no
action.
choice to do, but stay any enforcement action for a year, that gives you time to,
I'm willing to give him a year to figure this out and get this
I would
straightened
ask
out.
that you not put it to a vote and not make a decision, because if you deny the appeal, that triggers certain
Can you waive-
appeal
then
rights
can
that
you waive-
we have.
can you waive in writing timelines, and then I can continue for a year as long as you waive timelines for rendering a decision?
Well, my suggestion was to continue the hearing to a December meeting, and, stay the building inspector's decision for that 6-month period.
He's got to
Takes us-
waive timelines. I think there's a time within which we've got to
We don't have.
make a decision
with that.
once.
I'd like to hear what feedback this gentleman obtains, Roland obtains.
From
when
town
he-
council.
From town council and when he speaks to the planning board,
Mm-hmm.
so that we may have a path to resolution in a day or 30 or 60 days.
So let's continue this to next meeting so we can get
No,
things in
he's-
writing.
It's December. I don't think you're wrong to say continue to December.
covers
You
the-
waive
I just don't want
timelines.
to
That
trigger
covers 2 town
anything.
meetings if they have to.
But isn't the fact that if we don't take, I mean, if we deny the appeal, that's an easy road, and we can stay the enforcement for 6 months or a year very easily.
Can we do that versus just?
I'm not willing to just leave it up in the air.
A council is asking us to leave it up in the air because if we deny he's got appellate rights that he has to exercise within a certain period of time.
I'd
and
have
if
to
the
file
resu-
suit against the town.
Yeah, and
It's
if
not
the
something
result,
we want to do.
if the result isn't
Okay,
good,
that makes
ultimately he's
sense.
stuck without his appellate rights. So as long as he'll waive the time constraints for filing our
Can you do that
decision.
with a
I can do that on the
document?
record
Yeah.
now, I can do that in writing, I can send
Yeah, we'll
Sherry
give
an
you,
email.
we'll
or
give you
send-
writing to sign.
I can
So
send the
let's
town an
con-
email tomorrow.
continue to our December meeting at a time certain, with the expectation that you're gonna speak to town council.
Shelley, well, this is her case.
Okay, I'm gonna ask you to get on an informal discussion with planning board, see what they wanna
And
do.
Shelley's going to talk further with town council.
I have no objection to being there and representing either myself as a taxpayer, or if the board wants to authorize me to represent the board's position. That's up to you, at planning board's meeting.
Is there a more neutral person who can speak to the town about what it intends to do? She's obviously has an opinion, she obviously has a biased opinion as to.
I don't have a biased opinion, I'm just doing my job.
She is not biased.
Present facts,
She's
there's no bias, it's
It's
facts.
reasonable for council, however, to say that you're a party to the proceeding, and so unless you both can be on a conference call, he's unwilling to, or not unwilling, but he's concerned about one access to the town council with not both sides accessing town council.
So
And
we'll
that's a
just do
reasonable
it
position.
with email communication, that we're on the same email.
You want to do it by email communication?
And then you can get your input too.
My preference would be for Roland, I can't obviously volunteer him to do it, but that would be my preference, that he take the laboring law in this particular piece,
we ask
if
you
he's
to
willing
take-
to do that.
Can we ask you to take the lead with that? And that's no reflection on you, Shelley, it's just that it was your letter and council is disputing directly your letter, so.
I think Shelley could have represented it very fairly and honestly.
I know, but no court would allow that to happen, for one party to approach the judicial decision maker without the other
Well, I
party
don't
being
think of
represented.
that Chris Heap as being our judicial. It's going to be the planning board that's going to have to make this decision and figure this out.
Okay, so suppose I move that we extend this public hearing to 7:30 and whatever the date the December meeting is, subject to receiving an extension from the applicant.
A second.
Subject to receiving
The waiver of the
waiver of
timelines.
timelines. Do we have that here, Shelley? Do you want to send it to him by email and copy me
I
on
don't
it, so
have
make
one
sure it
with
gets
me,
signed?
so I'll send it.
We have it
by email.
upstairs though, right?
Yeah.
And subject to receiving your signed waiver by, I don't know, Monday. And what's the December meeting? Does somebody have a calendar to look at the third Thursday?
Yeah.
Third Thursday in December, please?
Well, it's probably going to be changed because we always change it.
Yeah, we might want to knock it the third.
Because
Thursday
that's
to
the
second.
Christmas.
That's Christmas
Yeah.
and Hanukkah.
No, I think we should still schedule, we can reschedule. We can change a meeting date, but just put it in,
It's
because
the
that's our date.
December 19th.
December 19th at 7:30 PM.
My sister's birthday.
Which makes me think.
Yeah.
And I would approve, I would like to move motion to say contingent upon the applicant waiving his rights of time. I don't know how.
That's part of it.
Okay.
That was in.
So who seconded that?
I did.
And all those in favor?
Aye.
Opposed? None. Okay, I am going to open the next hearing and then stand down. Thank you very much. 7:35 PM hearing.
Well, thank you, guys.
I do appreciate it, but I'm very passionate about it.
If it all works out, it's a good thing to get this regularized, because if you ever did sell, you encounter this. And the thing about all those lights are, we all sit and wait for the lights forever, and we're looking at your trucks, and all that's in our head is Neshoba security.
You know that stop line? I was promised that that would be on the other side of my driveway.
Oh,
Promised.
oh, so you can't get out.
Case number 928A, the petitioner Jenny Barron seeks a variance pursuant to section 17329, lot shape for a newly created reduced frontage lot at 6 Barron Way.
You gonna assign
I
someone to
have to,
take your
You have to sign two. I also have to recuse
so
myself.
I have a financial interest in the outcome of the matter, and I have to recuse myself.
I also have to recuse myself. I also have a financial interest in the outcome of the matter.
So, yes, we're calling on both of our alternates tonight for this case. Can you present the case?
Good evening, Bruce Ringwald from GPR, here with Jenny Barron. I believe you have a package. I have some 11 by 17 plans, if it's clear, if yours is too small. Okay.
You can share. I'm all set.
Yeah, all set. Stuff together there.
Thank you.
Okay, bigger copy.
Bigger copy, so you can see.
Now, there's also,
Yeah.
It's called us. You just called us old.
I ran out.
Thank you.
Bruce, there's also a town, like assessor's map that shows the whole neighborhood.
Yes,
Oh, here.
This one?
it's in the package there.
No, it's the one that shows, it's this one.
Oh,
Yeah.
okay.
Yeah. Yeah, I didn't enlarge that. I don't know
I
if
just
we
want to
put
make
that up
sure
on the
everyone
screenshot.
has that.
Janet didn't upload everything.
scribbling.
Oh, okay, you don't have access to the internet down here?
Oh, we do. I just don't know how.
It's on that computer.
So I could put on,
This is
put on
like
your
GIS
GIS map.
Mattawanna, that's four.
Oh, yeah.
Yeah.
Oh, that was in there, okay.
Did you need it, or just go right to it on the top there? On the desktop, there was an Explorer.
So, and this is the property
Just
that's
want
in
the
question.
GIS.
Yep.
And the reason I said, because there's 26 houses going on here.
Yeah, that new thing.
Yeah.
Wouldn't fit there. Then when you get to the map.
Is this correct, this map?
Oh, that's,
Mattawanna. This
Yeah,
is,
okay. Oh,
this
okay.
is this site there. Okay.
And hopefully she, there you go. Oh, you had it a second ago.
That's right now, it's 95, 20.
I think you closed out what you searched. Where it got there.
You gotta click on
Click-
6
click on
Mattawanna.
Yep, go back and click on the 6.
Down.
Down,
Down.
down,
Right
right there. There we go.
There we are.
Now close the box on the left. And if you zoom that out just a little bit so everybody can see, it
Yes.
should be about right there.
That's fine.
Thank you, Shelley.
That's perfect. Okay.
Okay, good evening. We're here this evening requesting a variance from the shape portion of the bylaw, which, memory serves me right, I'm gonna have to cheat and get the number, is section 17329, the shape bylaw portion of the bylaw. What we're asking for is to, the ability to divide this lot into 2 lots. One with a reduced frontage as the lot sits currently right now. The problem is that if you look at the exhibit from R. Wilson Associates that I handed out an enlargement of, in order to create another lot, we have an R factor of 0.35, we have to be greater than 0.4. My office has played with it many, many times trying to change that R factor, and we get very close to 0.4, but we can't quite get there. The intent of the reduced frontage was to avoid multiple reduced frontage lots, and you can see that there are several in the neighborhood. This one already exists, and what we would like to do would be to be able to divide the lot so that essentially where the blue dot is, which is close to where the house is, the lot line would kind of jog through that area and break off the portion that comes down to Spectacle Pond Road from that portion which is in the northern end up off of Barron Way. Now, we've had preliminary discussions with the planning board, and there is some general intent to entertain an A&R plan to allow for the house which actually accesses and fronts on Barron Way to continue to be in that manner, but we have to get her by the shape bylaw. So we're here asking for this variance from the shape bylaw portion of, for this particular property. It's unique in that we have this shape of this property that exists right here on this particular lot, and while there are other reduced frontage lots in the area, there are no others in the area that have additional land or potential other access to allow for this or to create this type of request for a division. The 5.2, 5, 10.1, 10.4, and on down the line are all right around the 2-acre mark. And as you may recall, with the reduced frontage, once you're at the 100-foot width of the lot, you have to have double the zoning area. So you have to have 80,000 square feet, or essentially 2 acres, and all those lots are just a little over 2 acres because you have your neck to get in, et cetera, et cetera. The zoning as it sits right now has imposed a financial hardship on the applicant. I think many of you are aware of her circumstances, and we're trying to create an additional lot to help out with the financial circumstances that are present. And that's basically it in a nutshell, and I'm for questions.
Could you explain what the shape factor is?
Certainly. The shape factor in Littleton bylaw, and I'm going to double check it because I work with so many different towns that have similar but different shape factors. 29, I think I said that was. Is you have the area of the lot times 16 divided by the perimeter of the lot squared. And then that number needs to be greater than 0.4. So what happens here, and on the sketch that I've handed out to you and given one to the abutters to see, you take the area of the lot coming around and you divide it times 16 and divide it by the perimeter squared, and we're coming out with 0.35. I've done other ones where when you create a curve, you get more distance and more area out of the curve, so it works out better. I get closer, I get to like 0.38, but it's, you know, it's semantics at that point.
But for reduced frontage, you can't get 80,000 square feet. And I guess you still have to get a 400 by 400 square in there?
150 by 150 square.
Okay.
And that's what's shown on the sketch plan that I've provided you for this, the sketch showing the subdivision.
So this conforms in frontage and area and in the 150-foot box, and the only thing it does not conform with is the shape factor.
That's
So the
100%
existing
correct.
house, not the new lot.
For the
No,
new lot. For the new lot.
Now, has it,
For the existing lot, you can see on here, they're at 0.7. You know, when I played with it around and tried with using curves and different things, that one drops to like 0.64 and the other one's at 0.38, but I'm still not there.
now you talked to the planning board. Have they denied an A&R for you?
We have not gotten to that point. We've had the discussion. And at that point, as I say, their issue is you're not meeting the shape factor. And so meet the shape factor, and then we can talk about whether or not they can issue an A&R, endorse an A&R, not issue, endorse an A&R plan.
To me, I think it's backwards. If they get denied, then we can come and issue, potentially give them a variance for the shape. But to do it ahead of time, isn't that kind of backwards?
No, because it's factually there. I mean, it's clear right now that this could not be endorsed as an A&R.
Well,
And so there's no point in, it's not even a matter of denying it, it's just, it would have to be denied. I just want to point, one of the things about variances is it talks about the neighborhood and the detriment to the neighborhood.
Correct.
And I guess when I look at the, there's similar lots, but there are also very much smaller lots. And I'd like to point out at the Cricket Lane, there's going to be quite a few homes on small lots. And that, to me, just plays into the way I feel about this, because this is the parcel now is 3.5 acres, or?
Yeah, I believe it's 3.2 acres.
Okay, so a single home on 3.2 acres, abutting a parcel that's going to have probably 25 homes on 10
Putting an
acres.
11-acre parcel, they'll have roughly 25 homes, yeah.
Okay, and so when we consider variances, the detriment to the neighborhood is a big factor, and we'll hear from abutters. But I don't see that dividing this property into two parcels would be a detriment to the neighborhood, as I see it represented on this map. But anyway.
Not considering the size, 80,000 and 40,000 square feet, we need to
Right.
bylaw in that regard.
So anyway, so let's take comments from the board, then we'll take comments from.
Want to hear the abutters first?
Abutter.
or-
No,
Oh,
let's
okay.
just talk and we can come back to our comments. But does anyone have any other comments? Any questions of Mr. Ringwald?
No, I think I agree with you that, looking around the rest of the area around it, having a slightly undersized lot is still many times bigger than most lots nearby. And it won't really.
Well, the lot is, let's be clear, the lot is not undersized.
No, but the
But the shape is.
The shape.
But I see
Yeah.
lots that look like they're little postage stamps.
Now, would a house be sited about in the 150-foot square?
Most likely, yes,
So you'd be able to maintain setbacks, no problem.
definitely.
Yeah, that's why you have to have the 100-foot square.
Any other comments?
As long
from
as
the
it's
board?
buildable there.
Yeah, the only
Well,
question
well,
I
that
have
should-
is what's the rationale behind having a shape factor? I mean, I have a rough idea, but I'm just wondering, I'm sorry, Roland, would you, oh, you know,
Well, no.
I'm just wondering what the rationale is behind it, other than having a really strange looking lot.
Yeah, I recall when the law was made or voted on, there was a subdivision on King Street over towards the Westford side
Partridge Lane,
that had all these little rat tails.
poster child for this.
They went up, over, down, and they were just little skinny rat tails.
There were like 10-foot sections that just sort of wrapped around each other.
And they had a
But
common
I'd like to
drive.
point out, this lot here might very well be a poster child to get the, I don't know, it just looks very suspicious, in terms of making a shape factor work on a lot like
Well,
that.
there's a whole lot of lots in town that the shape factor doesn't work, but the shape factor didn't come into play until '98.
I realize that, but that's what Mark's question.
Okay, yeah, I just
All right.
want to know the rationale behind it.
Yeah,
You know.
in every community that I work in that has it, it's typically exactly what Roland brought up, is that they have created rat tails and these very thin strips that run around, so you have a little square, you have 2 acre zoning, we'll say, and you have a little square that's less than an acre, and then you have this strip that makes up a bunch of land, and then there's a space way off in the back, and it's typically wetland or something, but it makes up the rest of the area. And you get the development of many lots that if you didn't have that shape factor, you would have had, instead of 10, maybe 3 or 4. So,
To me, the key is you get a 150-foot square, you can easily site a good-sized home upon the setback, so that's not an issue. If this was real skinny and they couldn't get that 150 in, then I would start to have problems with it.
The other question would be, if it comes to granting a variance, what would be the shape factor that you would, is it .35, is it .33, is it .38?
it'd be in the neighborhood of .35 plus or minus.
Okay, any other questions? Any abutters? Yes. Identify yourself and your address.
Leah Lee, I'm at 116, as of S1 up there, Spectacle Pond.
Okay, which one?
S1, I think.
S-
Down to 5, 5-1.
5-1, okay.
That's what.
Yes.
I guess I'm just here to learn more about what
Okay.
we're trying to do.
Anyone else?
Brian Rowe, 118 Spec Pond,
And which one would that be?
the one directly behind
5-2.
5152.
Okay.
I can't see.
Yes.
52.
Looks like that.
Okay. And your comment?
The first knowledge of this proposal I had was the notice, the official notice of this meeting that we got in the mail. Our neighbors have not been very neighborly in telling us about this proposal.
That's not for us to
No.
comment on.
But the question is, do you have some concerns or issues you'd like to bring forward to us?
Concern is I don't know enough about this to form an opinion yet.
Right, yeah.
Have you seen this?
This is the
Just
first,
now.
yeah.
Okay.
We were presented to it when you passed out the copies. Catherine Healy, 118 Spectacle Pond, same property as the gentleman next to me.
Okay.
I think my, one concern is that there is a fire hydrant in that area that, I mean, it's not for this board to discuss, but that fire hydrant is part of that. And there are a great number of lots that are reminiscent of Oklahoma, ours being one of them, and I'm not sure that that is conductive to a good neighborhood. We had the big challenge in the lot next to us with the Cricket Lane development, and I am hesitant to get on board with this proposal for another major construction project, although of a much lesser scale, but still.
It's one home.
One home, but it's more parsing out of this area. And is that the character that we want for this area?
One home on 2 acres.
Additional parsing of land that was already previously divided and had been this way for, however, I have concerns.
Okay.
The parsing of the land adjacent to us, Cricket and Spectacle Pond, was a big challenge over the last year. And I'm gun shy about another proposal on the other side of our property.
Okay. Any further comments?
One more.
Oh, one more?
Just one more.
Oh, yeah.
Just a question. So Stacy Scott, I think I am 10-1 or 10-4. Can't see.
Okay, so are
10-1.
you
I'm a
behind?
Yep, I'm right there.
Okay.
So my only question is, and maybe Jenny's been able to look more into this, is the driveway seems to be disruptive to 4 properties, if I'm reading the map correctly.
Driveway
Is that right?
would be.
So it's cutting through the 4 properties?
Yes.
And from my understanding, in order for this to be parceled out, this, in any other way, Barron Way, if the house were to be off of Barron Way, we would have to change Barron Way as a neighborhood. The road would have to be widened to add another house to that neighborhood. So, but my question is, if the driveway came from Barron Way, would there be any waivers that we could pursue so that the driveway came from Barron Way, but those major changes wouldn't have to be made to the road?
Can you speak to this?
Yeah, Barron Way for a private way is in very nice shape. It's a fairly wide, recently paved. It's been realigned. It doesn't follow the alignment that you see here. Where the N in Barron is, it takes a 45-degree left and then runs over parallel to the yellow line right about where the 5-5 is. And hooks back around and goes on through. A driveway could service this new lot potentially off of Barron Way, adjacent to the little spike that goes down to Barron Way on the diagram that it was presented by Wilson Associates, or that could be widened, or it could be a quote-unquote shared without having to go through the shared bylaw portion. To come off of there, or it could access off of Spectacle Pond. There are options, and the applicant is open to either option.
So this question came about with someone who lives on Barron Way. Now you have frontage on Spectacle, but you access your house from Barron.
Yeah.
Yeah. Okay.
Yeah.
We've had a lot of Barron Way stuff in this board over the years. Anyway, so the question was, if this parcel wanted to have access from Barron Way, would the planning board require improvements or changes?
I'm not certain. I know that we've, in different communities, I can't think of one particular one here, obtained access. It comes down to, is there adequate access for emergency vehicles? And for an additional lot, it comes down to that, and it's a judgment call that's of the board's nature. So I can't speak to what they would say.
Would there be, would you consider, or the applicant consider, if we granted a variance, a condition being that the driveway come from Spectacle Pond?
I think yes, but I think that really limits things, and that may be of more of an intrusion on other folks, because it may be a longer route. As you look at the sketch that you have, that square is further back on the property, and it'd be a shorter access. It could even access right off from where I talked of the bend of that road, right off of the side, so that it's, it will have gone by 2 properties when it hits this new one.
I think how subdivided where the driveway is should be up to the planning board.
Okay.
So, because, we don't have enough information, especially if the road is not shown correctly.
Yeah, it's not by too much.
Any other comments? Any other butters?
You can see it on the web.
Do I have a motion to
Jeff?
close? Yes?
Can you read my comments?
Oh, thank you. 6 Barron Way. The applicant is seeking a variance pursuant to section 17329 lot shape for the subdivision of a lot known as number 6 Barron Way, lot 3, map R23, parcel 53 containing 3.19 acres total, which is on the map here. The required lot shape is 0.4. The proposal for the newly created lot is for lot shape 0.35. Based on the information provided with the application, this calculation cannot be verified. The plan submitted does not show lot dimensions. In sensitive use section 17327B, changing of lot dimensions states that no existing lot shall be changed in size or shape so as to result in violation of the requirements set forth below. The subdivision of this lot would create a second lot in the rear, house number 6 Barron Way, with no frontage, as Barron Way is not a public right-of-way. A similar A&R was presented to the planning board in 2011. The board did not approve the plan and made the following finding. Barron Way is within a right-of-way 20 feet in width, too narrow to provide for the needs of vehicular traffic and for the installation of municipal services to serve the buildings, and no information regarding the construction of Barron Way was provided, making it impossible for the board to make a positive finding regarding the adequacy of construction to provide for the needs of vehicular traffic and for the installation of municipal services to serve the buildings attached. The creation of the 2 proposed lots would result in creating 2 non-conforming lots, one with no frontage and one that does not meet the lot shape. That may be, but that's not in front of us. What's in front of us is whether we would give a variance to proposed lot 3B for a variance from the lot shape requirement, and then it would be up to the planning board whether they accept the delineation of the lots.
Yeah, because by separating the lots, the existing lot has frontage, right?
Yes, it has the 35-foot frontage on.
Yeah. So when you subdivide it, Jenny's house that's listed here.
Right.
No longer has frontage.
Right.
So that's the planning board's problem.
As do all the properties on Barron Way, the front on Barron Way have no
Right.
frontage. So it's
Well,
not,
some do.
well, some do, but most of them don't. But that's not our decision.
Okay.
That's the planning board's decision. They could say, fine, you have this variance.
So we give permission for the variance, that gets them around the .4 rule, but they still need to go to the planning board to
Yes.
get permission
For the A&R.
for the subdivision.
Yeah, right.
100% correct.
Okay.
Also, I would like to point out that these comments were from 2011, and I don't know, but I suspect from comments that there has been work done on Barron Way since 2011.
Most definitely.
And those comments don't, that work might be in reaction to these comments, so for whatever that's worth. Okay, any other comments? Can I have a motion to close the hearing?
Move we close the hearing.
Second?
Second that.
Do we want to
All in favor?
deliberate? Or are we done deliberating?
You have to take a vote.
Oh,
to close the hearing.
To close the hearing. Thank you, Rob. All in favor of closing the hearing?
Aye.
Opposed? Now, can I hear a motion from someone? Are we at that, I think we're at that point? Anyone?
I think we are.
Anyone want to take a crack at forming a motion? Go back to the agenda. The petitioner seeks a variance pursuant to section 17329 lot shape for a newly created reduced frontage lot at Barron Way. The variance would be to allow a proposed lot 3B as delineated on the drawing by dated 8/2/18 by R. Wilson Associates to have a lot shape of .35.
Plus or minus. So it's
Well,
You would,
if we give you a variance, you have to, can you work with .35?
If you give me a plus or minus a little whisker, that would be helpful.
Well, then let's do .34.
All right, that'd be great.
That's fine.
That'd be great.
Yeah.
0.34.
Oh, you're just not confident in this particular number? Okay.
There's a shift in the engineering firms, and we've not done a survey of the property, so I can't guarantee that I'm gonna hit the .35.
Okay.
It's just that we can't get plus or minus, then becomes.
I understand.
No, we don't want to do, yeah, .34.
.34 or greater would be
Yes.
great.
Okay, .34 or greater. Motion's been proposed.
That sounds reasonable.
And can we have a vote on it? Who was it?
Second.
Okay, second?
I'll second it.
Okay. All in favor?
Aye.
Any opposed? So we will grant that variance.
We thank you very much for your time.
And then you go to the planning board and deal with that. Okay, let's get Sherry back in here. This is hard.
I don't like
I don't know where she is.
I'm sure she's somewhere there. Come running.
This is probably fine.
Very discussion, not that it would have changed anything.
Interesting.
Yeah, it just, yeah, to me,
And planning board may say no.
So it's Ruth? Happy birthday.
yeah, so there's a variation, and that's not, well, do you remember the church? Yeah, the church. The church. The alternative, no, it was alternative.
A variance.
Yeah, it was supposed to be
School.
school, not a church.
He still needs to go to
Oh, yeah, I remember that.
planning board to get all the other approvals.
That just kind of.
I'm sorry I didn't get to see you in action for the first time.
Yeah, okay.
John, I'm Cheryl. Nice to meet you.
Yeah, yeah, it was right next to my autonomous.
Where do you live?
Okay.
I live on Beaverbrook Road.
Plaza. And then that place.
Well, we're not too far off. We're opening the 7:45 discussion at 8:45, the continued public hearing of case number 922A. Petitioner William Vale seeks an appeal of the decision of the building commissioner dated March 22, 2019 for property at 580 Great Road. Now, I don't know if more has happened since then, since our last meeting.
I'm not sure of what they're doing, so.
So just to bring everybody up to speed, we're missing someone. Where'd Rod go?
Find you too? I think.
Oh, okay.
He'll be next door to drink fountain.
Just wait a second till Rob comes back in.
Boy, are we
No, I
appealing
wasn't
you
at
a
the
lot
last
tonight.
meeting that this was discussed.
We're appealing you guys a lot.
You weren't at the last meeting when
Yeah,
this
we
was
didn't.
discussed.
Right.
Have you read in? Are you up to date?
Yeah, I read up and everything, so.
I was not at that meeting either,
Oh, the minutes? No, it wasn't either.
but
All right, so were you here at the last meeting?
then why don't
And
you
you
hop
weren't
in?
here at the last meeting?
I was not.
All right, so why don't you continue, I'll appoint you as an alternate. I'll ask you not to sit on it. Were you here at the meeting when they presented the first time?
Was that
The
last week?
Vales Last month.
No.
And
I was.
You were here, I was here. Were you here last month?
No, I wasn't, but I did read up.
You
on it.
read up, so you're up to date. And did you read up?
No, I didn't.
I
realize
have gone to the property, turned around in the
Oh, well,
driveway,
it's more than I've done.
and done the
One,
research.
2, 3. So why don't I leave you off this time and let John continue and you stay on?
And Mark stays on?
Yeah, you've read in, okay?
All right.
And you weren't here, so, okay. So you want to summarize where we were last time and what the complaints are?
You
Just
want me to
summarize. Yeah,
recapitulate?
just for the board members who weren't here last
This
time,
is-
yeah.
Okay.
Revisit it. You've got some pictures.
So we were here a month ago. I had
I guess I'll just recapitulate everything that was already said. We have a situation at, well, let me rewind a little bit. My name is William Vales. This is Carol, my wife. We live at 576 Great Road. I've lived there since 1986. Carol has been there since 1990. I've lived in Littleton since 1978, and Carol is about the same. Our property, our neighbor on 580 Great Road, about, I want to say about 7 years ago, started to be, we have a very long driveway that goes up, okay, about maybe 600 feet. And there started to be quite an accumulation of garbage, trash, mattresses, bagged cans, things of that nature. We went by that and mused for quite a while of how we need to resolve this issue, but always whizzed by it to get up to our property. And then one day, I saw the neighbor using our driveway as egress, coming across their property onto our property, using the driveway for egress, okay? And then as I looked a little closer, I saw a lot of tracks on the property, and I could see that had been done repeatedly. Okay, so I approached the person that was on the porch at that time to ask what was going on. I mean, I knew what was going on, but I wanted to hear what he or she would say what's going on, and I didn't get any resolution out of that. So right after that, I realized that we weren't going to muse over improving our scenery. We were going to act on it right away. So we commenced to resurvey the property, construct a fence, okay, take down whatever trees we have to do, figure out how to reconfigure the driveway, and we did all that. The neighbor at, so I put up stakes to bound the driveway. The next day, the stakes were blown over. Okay, you could see the car tracks. They were just blown over by the neighbor. And I went down there to reposition the posts. And the neighbor had some words for me. And the gist of my words back to him were, the fence is going up, period. That was it. I really tried to maintain composure through this whole thing. And so then we commenced to putting the fence up, reconfiguring the driveway, taking down whatever trees, resurveying the lot. It was great expense, quite frankly, okay? So we got that done. So about 3 or 4 years later, I forget, I have it in the notes here, we noticed, well, actually it goes back to last November. We noticed a tractor starting to, on the neighbor's property, starting to push back, started to do clearing of land, so to speak, very rough clearing. And then we noticed a number of trailers that came in. Okay, there was 1, 2, 3 trailers, various, a truck, a little cabana put up, fake grass put out so the illegal dog could go outside. And, you know, somebody was setting up shop. Okay, this was on November 28th. And there you see the picture of that, November 28th. If you press the I, please, on this, you'll see the metadata. I'm not sure what browser you're using.
What do you mean by metadata?
Well, the metadata, you know, so you would know when those pictures were dated. I want.
We'll take your word for it. When was the picture?
Okay, fine. So the date, all the dates are on there, recorded by the camera.
What date was that?
That was November 28th, I believe, okay?
Of 18.
Of 2018, that's
Okay,
correct.
I thought you were-
Yeah, 2018. So the idea was, and I reported this at the time to, let's see, I went to Diane Crory, and I believe I spoke to.
Now, where are you when you're taking these pictures?
I'm on my property, I'm.
Are you in your front yard?
No, I'm not. I'm on my driveway. I'm next to an outbuilding, and
And we're situated up higher.
yeah,
than you.
and we're situated up higher.
But that is our front yard. It's facing the road.
So the previous one, can we go back? There's a car parked underneath the tarp?
Yes, yeah. So the intent of my pictures was if someone is living there, I wanted to give you some sense, or I wanted to garner some sense for myself of the comings and goings of vehicles and people, you know, to see if in fact someone was living there. When I went down to Diane and informed her of this, and this has been an ongoing situation with cars, that the police had as I understand it, had fined them for having a number of unregistered cars there, and that would all be documented with the police department. My understanding is that they fined them fairly hefty to come into compliance with the number of unregistered cars. There were as many as 8, okay, at any given time. So my idea was, let me see if someone is really living there. So I started taking pictures in the morning, in the evening, you know, whenever I was there. You know, I'd start taking pictures. And, you know, in time, in my mind, you know, I'm accumulating empirical data here that's convincing me someone's living there. There's no question. I mean, there's lights on there, and the metadata, if you look at that, would show whatever time of day that was.
Up in the upper left corner.
So that was the gist of the pictures. So it became clear to me someone was living there. Okay, and I would see this truck coming in with the commercial plates on it. That would come in, and then the car. It was a 2-vehicle household, let's say. Okay, they had a truck there to run whatever business they were doing, and then they had their car there to go out, whatever.
Did you have the minutes? Do you have the minutes from last week? I printed them out, but I didn't bring them in. I'm wishing I had the minutes from last. How was this hearing left last?
It was.
So let me.
Why was
yeah.
it continued?
Okay, so
I just don't have the minutes. I've read all of your material.
Okay.
I've gone to the property. I've driven all the way up the driveway, turned around and drove back out.
When did you do
so
that?
let me-
if I may?
This afternoon.
Okay,
Let me bring everyone up to date on this.
I just don't know where we left
So the zoning
it.
enforcement officer wrote him and said,
He said I had 30 days to appeal his finding.
no, we need to read the letter that was
That-
written by the zoning enforcement officer to you. It said, May 22, 2019.
Yep.
I'm forwarding my comments of March 22 of this year. This is from the zoning enforcement officer to, oh, no, to you. Do you have your letter? Can we read your letter? Yeah. It says, April 16th, 2019. You said to Roland, I'm addressing this response to you. I need to find Roland's ruling, I'm sorry. I need to go back. To Roland's letter to you before April.
It was an email.
Yeah.
Yeah.
So in April, Roland wrote you and said, find the April letter. I don't know why it's not in the file here.
I don't,
You have it, Sean?
That's my whole
Thank you.
packet from
Yeah, here,
last.
hold that. Thank you
Well,
for
that's-
bringing it.
oh, yeah, that's
This is Roland's letter to you. Who's
Sent
sitting?
on March 22nd.
Okay. Dear Mr. Vales, I am in receipt of your letter explaining the conditions on the property abutting your own. It's clear that you're unhappy with the current condition regarding the use and storage of material on the abutting property. To summarize your concerns regarding code violations, please note the following. Camper trailer, business operation, storage of utility trailers, materials, and equipment, storage of trucks, storage of a car, a barking dog, and evening fires. Of the several items mentioned, 2 could potentially fall under the jurisdiction of the building department. 1, mobile homes are specifically prohibited in the town of Littleton unless in connection with a natural catastrophe. Camper trailers are not mobile homes, are self-contained and permitted on residential property for personal use. Both the building code and the Littleton zoning bylaws are silent on camper trailers. Mass does regulate campgrounds, but this situation is not a campground. 2, business operations are allowed in residential areas provided they comply with Section 17354 of the Littleton zoning bylaws, which I imagine is the home occupation bylaw. To the best of my knowledge, there is no evidence of activity exceeding the limitations of said code regulation. I'm afraid at the moment there is little I can do to resolve your concerns, and then it goes on with your rights of appeal and how to take your appeal.
Yep.
So Mr. Vales appealed to this board, and we had a hearing last month. And at the hearing last month, this board concluded that the issue of camper trailer and potentially a Board of Health violation if someone is using a camper trailer as living quarters without a proper septic disposal system falls under the jurisdiction of the Littleton Board of Health and not the Zoning Board of Appeals. The business operation we felt was a zoning enforcement ruling, and there did not appear to be any evidence of a business ongoing at that property. There was storage of some business equipment, but there didn't appear to be business activities ongoing. Storage of utility trailers, materials, and equipment does not seem to have a zoning bylaw that I know of that we can enforce. Storage of trucks, storage of a car, unregistered motor vehicles falls under the jurisdiction of the police department, which has a bylaw, a regulation about unregistered motor vehicles and the number you can have on the property. A barking dog falls under the jurisdiction of the town clerk, who licenses animals, and the animal control officer. And the evening fires, we felt as a board, fell under the jurisdiction of the Littleton Fire Department. So we asked for the case to be continued for a month for this board to write letters to all of the boards and committees that would have anything at all to do with any of this. And a letter was generated from our board to Board of Selectmen. I think it went to the Assistant Town Administrator, but it went to the Littleton Fire Department, it went to the Littleton Police Department, it went to the Board of Health, it went to, well, let's see who answered it, I'll tell you who else it went to. So Scott Wazinski from the Littleton Fire Department responded on May 22nd, 2019. In regards to the campfire issues, did you see these letters, by the way?
No, I haven't received any copies of those.
Okay, we need to get copies to him. Does anyone have in their file copies of these letters that I could give him a set to read
Sure,
along?
we've already read them.
Okay. Thank you. Thank you. From Scott Wazinski of the Littleton Fire Department. In regards to the campfire issues, I have spoken to Mr. Vales on several occasions and stated when he observes a campfire or the use of accelerants to notify the fire department, and we will enforce it if it is an illegal burning. However, if it's a small fire used for cooking, then it is allowable under our regulations. To date, we have been called one time to investigate a burning complaint, of which it was very minor in nature in a contained area. That's from Scott Wazinski of the Fire Department. On May 22nd.
May I add?
Yes.
That on February 14th, that was the day that I went to the fire department, okay, to notify them of a fire. And it was fairly significant in terms of, poof, you could, see
Was it
accelerate.
during the day or in the evening?
No, this was in the
So
evening.
it wasn't like a burning
No,
type fire?
no, not at all. This was probably around 7 at night, okay? And then on another occasion, it's in my chronology, but on another occasion, the police were up there in the early evening, about the same, for 2 barking dogs. And when I was talking to the officer, I said, and another thing that I'm really concerned about was that, and I pointed his attention to our fence, and on the neighbor's side of the fence, you could see the burst of flames. And I said, I think they're burning building materials, because I hear saws going out there, circular saws, okay, and I see stacks of pallets, okay, 5, 6 feet high. And in the morning, you would go out and you wouldn't see pallets, quite that high. So common sense just told me that those were being burned, and the police officer said, I'm going to go right down there after leaving here to let them know about it. So I presume that the police officer made a report on that, and that would then constitute, to my knowledge, 2 reports that I made on fire.
So continuing, so the fire department weighed in that they did not find yet a violation of the fire regulations and the burn requirements and the burn permit requirements in the town. That is not, we explained to you last month, I tried to explain to you last month, that's not a zoning enforcement matter. This board has no jurisdiction over whether fires are legal and lawful on that property or not. The second issue was, I asked the board also to write to your neighbor, who was not present at the first hearing, the owner of 580 Great Road, because I felt like if we were complaining about him and he was involved, he should be allowed to defend himself if he wished to. And he wrote back, hi Janet, here is my rebuttal to the one neighbor that has complained about me. 1, no one occupied the camper overnight. 2, the fires I have are in a pit and I was cooking food or cook food on it and therefore would not use accelerants, ! 3, there are no unregistered vehicles on my property, and he attached to this email registrations to all that are in my yard with a picture of each vehicle. And then he said, I have 1 dog and he is licensed, not several as Mr. Vail says, again, ! I have a friend that comes over from time to time. He has his dog. I invite you to come over and see that I only have 1 dog. Now, do you have a copy of that letter?
No, I don't have a copy of any
that letter as well. Thank you. Do I have another copy of that to stick in the file?
Here.
Yes, thank you. Here. And then there were letters that I got on the email that don't seem to be in the file from Board of Health. Do you know where that is?
No.
Do you,
Janet was
anyone
supposed
see
to
the
print
Board
it
of
out
Health
today.
letter?
I didn't know
See
where
if I
any
can
of them
find it
were
on my
today.
email.
Let me see if I can find it in here.
The Board of Health determined that no one is occupying the camper and that campers have self-contained units for discharge and waste and effluent, and that is perfectly legal and legitimate to sleep overnight in a camper on your own property as long as you're not discharging that into the ground.
If you're the owner, correct?
It didn't specify. It didn't specify. And the other thing that we do have jurisdiction, and the police reported that they didn't have, did you see the letters at all? I don't know why they're not in my file. The police reported that they didn't find any unregistered motor vehicles when they went as a result of our letter from last month. Now, he might have moved them since then.
Yeah.
But so the only thing
these aren't all the vehicles there.
The only thing this board has jurisdiction over is home occupation exceeding the limits of a home occupation. And, the camper is no longer jurisdictionally ours, that's Board of Health. So home occupation is the only thing we have jurisdiction over. Now,
If there was noise exceeding a certain decibel, you're not complaining about noise. Are you Mr. Jones back there?
No, I'm going to ask, are you in a butter that wants
I'm
to
in a butter.
speak?
Yeah.
Would you like to speak?
Yes.
Yes, please.
Oh, hi.
And identify yourself for the record.
My name is David Autio. I live at 570 Gray Road. Carol and Bill and I have been neighbors for 22, 24 years. We're separated by one driveway by another neighbor, so that's how close I am to them. I'm a concerned neighbor. This person that Bill's been and Carol are complaining about have had a long history in my mind of being a bad neighbor, and I'm just here to support them and let you know that he is a bad neighbor.
We can't spank bad neighbors,
Well,
unfortunately.
somebody should be able to.
And there are several others that have been brought to our attention across town. In fact, I have one right down the street from me.
I am not.
They're between you and I.
My mother said that it's easier to be a good neighbor than a bad neighbor, and she'd always
So,
repeat that to me.
things we can take up if there's noise things. You had one picture up there
I
of a
understand.
very large fire. Have you shown that very large fire to the police chief, that picture of the very large
I
fire?
had a police officer up there
And he saw it.
when he saw it.
You need to show the picture to the fire chief and tell the fire chief that this is occurring frequently.
Well, I went down to the fire department also. Now, I understand that there was a host of violations here, or maybe I won't even use the term violations because you may hesitate to agree with that term, but I have a host of items here that I was at wit's end, not knowing who to send that to, okay? So I sent it to a number of boards. You were not included on the board, on the initial mailing of this. I sent it to the Board of Selectmen, the Fire Department, the Police Department, the Assistant Town Administrator,
I think it's right here, yeah.
Town Clerk, Roland. So I was well aware that, you know, I didn't know where I was going to wind up in this process, but I said, I just got to let everything out. Okay, and you sorted out. So now you said that there's two things that you can deal with, but I think you've just now knocked that down to one because you've pushed that off to the Board of Health, correct?
We didn't push it off to
Well-
the Board of Health. We have no jurisdiction over that.
Okay.
And procedurally, why you're here is because you asked the zoning enforcement officer to do something about all of the complaints that you had about this next-door neighbor, and the zoning enforcement officer found only one zoning possible complaint that he had the ability to investigate as a zoning enforcement officer, and that one was home occupation and the camper. He concluded that the camper was not a mobile home, and therefore he has no jurisdiction over that. And we went a step further for you and on your behalf to ask the Board of Health if they have jurisdiction over the camper, and they concluded that they do not. So what's left is the zoning enforcement officer's letter that he has no jurisdictional rights over the camper, and Board of Health concurs, and our zoning bylaw has nothing in it about campers. So his letter to you about having no jurisdictional rights over campers is accurate. And the last thing he said was, this doesn't look like a home occupation to him. He's got no evidence that there is more than one employee on site. Now, there's a lot of contractors around town who have equipment that looks just like this, that all belongs to them. There's probably a lot of people around town that have pieces of snowplow or machinery or excavators in their yards, canopies and tents over their cars. None of that elevates to a home occupation unless you can show that he's running a business out of it.
I provided empirical evidence. I know Roland and his assistant were up there at least 3 times, maybe 4 times. They had provided me some dates that they were up there. Now, I wouldn't have expected anyone to have seen a pattern of occupancy if you're going up and you're leaving.
Can I take you down a different path?
Go ahead.
I looked at that trailer, and it looks like it's got roots. I gotta tell you. Has it moved at all?
No, and have you looked at my...
If it's self-contained septic system, what the hell's happening to the septic? And that would be something that the Board of Health would be interested in and could pursue. Because if that bathroom's being used and they're just dumping it on the ground, that's something they could look at, isn't it?
So when I investigated, in order to have that occur, you have to have water supply. There's no water supply to the trailer.
Right.
Oh, so they're just sleep, because that trailer.
Just going in the house.
Well, we don't know if they sleep, and
Sleeping and going in the house.
That's what he's saying they're doing.
I suppose I could go one step further and say I spoke with the fire chief about the individual that was visiting there, and he's no longer there. He has since moved to, I don't know if it's Mill Pond Apartments or wherever. So that condition, even if it was existing, is non-existent now.
Okay, but
Not that I know of, but that's...
No, but even taking that as hearsay, that sort of says that someone was aware that they were living there. I mean, I know they were living there. Carol knows they were living there.
What we're saying is there's no zoning bylaws against someone staying in a camper, a self-contained camper on someone's property.
You can invite a friend to come live with you, and whether he lives in a bedroom in your house or in the camper in the yard, it's legal.
Well, that certainly isn't my understanding from
You can't put a
reading
mobile
this.
home there, but there's a difference between a self-contained camper and a mobile home.
Well, at the last
Is what they're
meeting,
telling us.
at the last meeting, you had said, I forget the terminology you used, I would have to go back and review the thing, but you had said that I forget the terminologies, that you would agree or acquiesce to my definition, that your definition in here of mobile home fits the definition of the object
What I said was, it sounds to me like there's a fine or a lack of distinction between a camper and a mobile home. The problem is, I've since been educated that the distinction is the plumbing, the self-contained disposal. What do you call it?
Water in and sewage out.
Water in and sewage out is not happening in a camper where it does in a mobile home, is
Well,
it?
it certainly is happening in that has the facilities on it.
The difference is, and you can reference the building code, which reference this sort of thing. A mobile home is designed to be mobile across the roads, placed on a foundation, strapped down, tied to a septic system. Campers are just plain mobile. And the building code will tell you that we don't have jurisdiction over campers. They're recreational vehicles, and we don't do recreational vehicles.
It's not that we don't want to help you, it's just that we can't figure out a way to.
Well,
John is new to the board, he's a new alternate, and we always encourage our alternates to have an opinion and speak out, and I'm curious whether you've had this, whether you've confronted this in any of the jurisdictions you've worked in, because you've got a lot of expertise.
We have, and I agree with the building inspector.
And what is that you agree with?
That it's not a mobile home, that it's a recreational vehicle.
But the definition, here, may I read your definition? A mobile home, a movable or portable dwelling unit on a chassis, designed for connection to utilities when in use, and designed without the necessity of a permanent foundation for year-round living.
For connection to utilities when in use.
And designed without the necessity.
I'm sorry.
Should I read it again? Yes. Mobile home, a movable or portable dwelling unit on a chassis, designed for connection to utilities when in use, and designed without the necessity of a permanent foundation for year-round living. I assert that the object that I described in my letter and used the term camper, okay, that the object that I call the camper fits that definition.
It looks like there's extension cords going out there.
So what? It's getting generated on the back too.
So where in our bylaw do you deal with mobile homes? What's the section for mobile homes in
The
our
only
bylaw?
section we have, and I don't know it off the top of my head, is mobile homes are allowed to be placed on a property during reconstruction
Temporary
or
accessory
a
uses,
fire or so on and so forth. We have a
Emergency.
mobile home park that's
170.
pre-existing our bylaw.
17356, it says, special permit may be granted for use of a mobile home as a residence during construction, reconstruction, or extensive remodeling or dwelling on the same lot. The permanent septic system and water supply must be in place and usable. And the mobile home must be connected to them. The permit shall be limited to a reasonable time.
And that mimics Mass General Law.
Yeah.
Yeah, one of the biggest differences is the camper has a plate on the back of it. Usually it's.
It's also self-contained. I want to say the definition of a mobile home is it's designed to connect to utilities.
Mobile homes don't have storage
An
tanks.
RV is not designed
Right.
to be
RVs
connected.
have
So
storage tanks, mobile homes don't.
You can't call this a mobile home.
So,
But mobile homes
so whether it's, so,
Mobile home has no
so
storage tank on it.
you object to the physical presence of this or the fact that it's occupied? Because the physical presence is not something we can do.
No,
in-
And that I
Somebody living
understand,
there,
that I completely understand. What, the issue that I have is someone living there, okay, that is not, I assume, is not the owner of the property. Okay, now, is that space being leased? I don't know, okay? Is space just being leased for cars? I don't know.
I need to just stop you for a minute, and that is, someone suggested to me in response to last month's, someone said to me, when my parents were divorcing, my mother kicked my father out and he lived in a camper on the lot for a year because he wanted to be near the children. There are plenty of instances. When I came to Littleton, my house was in such a sad state of disrepair. We lived in a camper while we did the work to you know, the elbow grease necessary to move in and live in our house. There's not a prohibition against living in a camper on a lot, whether you own it or whether you're a relative or whether you're a friend or whether you're someone else. When you were here last month, you did say, and you identified who you thought the occupant was.
Yes,
And-
because that was identified to me by the police.
And I frankly had a little consternation about the fact that this may have been a person who might otherwise be homeless or a person who might actually have nationality issues, and I had some sympathy for that possibility. I've since learned that he's relocated and he's no longer there, but that was an issue that was going through my head last month as well. But I take great sympathy for you. Your property is lovely. You maintain it beautifully, but you can't control how your neighbors maintain their property. And there's nothing here that elevates to a zoning violation that I've seen or that the building zoning enforcement officer has seen yet. And I don't see how we have any ability to do anything but make a decision. What's procedurally before us is not whether this mobile home or this is a mobile home or this is a camper. What's procedurally before us is, do we override the zoning enforcement officer's conclusion that it is a camper on the lot that he has
No jurisdiction over it.
no jurisdiction over, and that he can't see evidence of a home occupation? Those are the only two issues that are confronting us. Everything else about the unregistered motor vehicles, and you can identify 3 or 4 properties in town where this issue of pack rats living next door come up over and over and over again.
One on New Estate.
And there's nothing we can do about it. There are neighbors who have complained vehemently.
Your two examples, which I understand, of a divorced family, okay, I believe that would be covered in your bylaws, because perhaps in that scenario, they are both still owners of the property, so the owner would be living in.
It has nothing to do with ownership.
Well, I think reading this, it does.
There's nothing to, no, because it's a camper. There has nothing to do with ownership and who's sleeping in a
Well,
camper.
how does the camper differentiate?
The-
How does that object get differentiated by your definition in here, or.
But what if it's a tent?
Well.
It's a recreational purpose that someone might be staying in every now and then. Is that?
But a tent doesn't have facilities to connect to, septic system.
I think this does bring up some interesting things, like, for instance, have you gone on Airbnb? Is he listing his camper on Airbnb? Well, how would the town deal with it? I mean, you laugh, but there are people out there, I've met some in town who rent their bedroom and do it like 100 nights a year. So
Okay. It's 9:25, we're
going down
straying
that
from the
road.
topic.
What we can advise you is when there's a big fire, take a picture of it, call the fire department.
So-
When there's trash that blows across your yard, who do they call about that? What?
ED.
The police department. You can annoy them, annoy this gentleman enough to make him be a better neighbor, but we cannot spank him. There are people, I have a neighbor I would like to spank. I cannot, it's not her. But, it's just, we cannot. And I wish we could. Our sympathies lie with you and you.
So you didn't receive anything back from the Board of Health?
We did. I don't know why it's not here at the meeting, but I will make it
Probably
available
pull
to
it
you.
up on my phone. If it was in the email.
It was from Janet Fairchild, and it was.
It came through today.
Came
and
through
with
today?
a letter of.
There was something earlier on from Jim Groffey.
And you accept the statement, I mean, I would expect that, I guess you'd have to, I mean, he says no one's been leaving there, yet I provide you some empirical evidence, which I don't know if any of you have looked at, all the pictures in the metadata, okay, to see the dates. And you could probably ascertain, if you looked at those pictures, why I came to the conclusion that someone is in fact living there, at least for that time range of those pictures, okay? But I'm really not getting the sense that that's been investigated, looked into.
What the problem is that even if someone is living there, that is a Board of Health jurisdictional matter. It's not ours. We do not control who lives in properties. It's a Board of Health matter. We need to make a decision on this particular set of facts that's in front of us at this time. That doesn't prohibit you from going back again, making another complaint to the zoning enforcement officer, having another letter, and bringing this back again. That this is not res judicata or, it's done. At this point in time, there's no one here, no evidence that there's someone living there today or when he inspected it, and there's no evidence of a home occupation.
Well, again, I wouldn't expect someone to ascertain someone is living there by going up, taking a look, and leaving. You'd have to see it over time, and that was
Have you seen it over time since this fellow supposedly left?
I didn't know they left. I didn't.
So
know
have
they
you
left.
seen him coming and going yesterday and the
Yeah,
day before?
I heard him there today. I heard the dog, that person's
overnight,
dog.
sleeping overnight.
Well, you didn't ask that.
Well, that's what I'm asking, sleeping overnight there, because that's your argument. You say someone is living there and sleeping there at night.
Okay, but I provided the pictures from November 28th through April whatever, and then as I said at the last meeting, I was completed my photography career at that point, okay? Because I felt that, after seeing occupancy for that period of time, it became clear to me, Have I seen anyone there now living? I don't know. I haven't. But as you can see, there's a different line of sight this time of year, right? Than when I made the complaint, which was in March.
Has anything changed since we sent the letter to the neighbor telling him that you're in front of his board?
No.
None of the vehicles have left?
No, in fact, the one change was when my wife and I came home, when Carol and I came home from a long weekend, we got to see part of our fence destroyed, where the caps, about 5 or 6 caps, were broken off. And at that point, I called the police. They came up, okay, and looked at it, and, you know, we kind of looked around, looked in the sky, and, you know, common sense, you know, letting common sense reign, we determined that, well, it must be someone knocking them off, seeing they were.
Those, I thought you raised that last meeting, that those.
Well,
were-
I did, but I've raised everything I've said last meeting as well.
But the
so.
caps are before the letter went out to the fellow, those caps were off, because you
Well,
talked about those at the last meeting.
I'm not sure the timing of when you sent a letter.
Well, we sent the letter after the last meeting. And the caps were already off. 'cause
Yes,
You
yeah.
talked about those.
Yeah, okay.
So there was no quote vandalism or tampering with your property specifically since the last meeting that you're
That's correct.
calling out.
They're
Okay.
very good and very reasonable and cheap cameras these days.
They have cameras up.
I need, it's 9:30, I need the board to tell me if they want to continue the discussion, if you want to continue the hearing, if you want to close the hearing, if you want to deliberate, I'll take a motion.
I tend to agree with what you're saying. The two procedural issues that are brought up are essentially, you know, you're running a business out of a place, and is there an illegal occupancy? It's kind of clear to me that, for right or wrong, the zoning rules don't apply to a camper, which this is. So whether someone's living in it or not, you know, it's not against the zoning rules. Home occupancy, I'll bow to Roland's review that no, there doesn't appear to be a business occupancy above and beyond what's normally allowed. So, you know, in my mind, I feel for you. I'm fortunate, I have great neighbors, but we do get situations like this, and you know, there's just so much you can do. If somebody wants
I'm not
to
his
be
neighbor.
annoying, you know, if they want to, they will be. And
I understand the limitations of things, and I understand that you can pile up material, and I have no control over that. I understand that. I understand there's a range of what one considers okay and what the other one doesn't. But the idea that someone was living there, and I take a little bit of umbrage to any racial connotation or any homeless, you know, the person was homeless, because I have quite a bit of compassion for both, from personal experience.
I'm sorry, I didn't mean to imply that you.
Well, you did.
I'm sorry, I didn't mean that.
Okay, well, you did. You know, I don't feel that the pictures that I took that documented the situation was looked at. I don't get the sense that those were really looked at, that you thought about the chronology, looking at the metadata. Oh, yeah, this happened in November. You know, next day, cars coming, trucks going, cars coming, trucks going. I just don't get the sense.
No, I looked at every one of those pictures, but the problem is, even if I agreed with you that, yeah, someone was living there, it's not illegal.
It's not for us to say no.
Not us.
That's the problem.
No, I looked at all of those
The
pictures.
Board of Health deals with the fact that people live in there. We have nothing in our rights to say anything about that.
You can have a camper on your property, you can invite a friend to live in the camper. There is nothing we can do to keep that from happening year-round.
I believe your zoning regulations state that for someone to live in a mobile home, okay, and as I said, I still assert that that object is a mobile home. You wouldn't find any technical differentiation.
I do. I disagree with you. I do. The mobile home does not have storage tanks. Mobile home is tied to the septic system. That is a camper. It has storage tanks in it. It has no water line to it, which means obviously you're not using the toilet because there's nothing to flush with. It's a camper. It's a different thing. I used to own a camper.
And they should change the term on it, because what we're referring to as mobile homes are actually manufactured housing. And it's an old term that's obsolete, and as opposed to a recreational vehicle.
Well, I think you're kind of changing the rules here, because it makes, you know, what you've written here very ambiguous.
That's why we're here, is to
Well,
make that
then you
decision.
should, then you can go to the selectmen and complain and say that we need to rewrite. You can go to the planning board and say this definition is, that's not our purview. I think that your situation brings up a lot of questions, but we were asked to comment, to uphold Roland's decision, and what would we do now if there's no one living there? What would we do?
Well, I don't know. I don't know that no one is living there.
But
I don't know that. I mean, apparently, you take the comment by the neighbor at face value, and that's your prerogative.
But what we're saying, it doesn't matter if there is someone living there or not, we still don't have purview over a camper and someone living in it. It doesn't matter if someone's living. I have sympathy for you, I would like to help you. We're all volunteers on this board, we're all residents of the town, we would like to help people like you. But our hands are tied, it is a camper, no matter how you look at it. There is no regulations, planning, zoning board regulations against people having campers in their yard. You can harass the heck out of them, you can file more complaints against
No,
them.
I'm not gonna harass anyone.
Well, I would if I were you.
No, I wouldn't.
If someone was doing
I'd
that.
like the board to either make a motion
You can
to
keep,
continue
you can
or
keep
make a motion
complaining,
to
but we
close
gotta,
at
we
this
can't,
point.
we can't.
I make a motion to close the hearing.
Second that.
Okay, moved and seconded to close the hearing. All those in favor?
I'm very disappointed.
I'm so
imagine.
I'm
Both with
sorry.
your decision, with your perceived lack of preparation. I'm very disappointed. Thanks for your time.
Your board want to vote?
Sure.
I move that we uphold,
I think you deny the appeal.
I was gonna say uphold, the building inspector's response, but we have to deny his appeal.
Second?
I second that.
All in favor?
Aye.
Who seconded?
I did.
Mark.
I move to close the.
To adjourn.
To adjourn.
I second.
All those in favor?
Aye.
Show a lot more patience towards the end.